latest immigration news. We have 2 bad news and we have 1 good news. We're gonna start with the good news first. My name is Bijoux Ngwanda, as you know it. I am an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases every day. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, and don't forget to comment below. Also follow me on all platforms. Links are in the description box below. First news, the good news is that this Biden administration, as you know it, signed an executive order really paroling spouses of U.S. citizens who enter without inspection to the United States in order to open a pathway for them to adjust status and eventually getting their U.S. citizenship. How does it work? First, you have to have been here without parole or inspection or admission, okay? Without a visa. And if you cross the border without being paroled, that's qualification number 1. Number 2, must have been married a U.S. citizen as of June 17, 2024 or prior, right? The cutoff date is June 17, 2024. And number 3, must have been living continuously in the United States for 10 years as of June 17, 2024. 10 years, okay, of continuous presence in the United States. And number 4, be admissible, meaning that you don't have any other inadmissibility issues. Some inadmissibility issues can be waived, some cannot. Some immigration offenses cannot be waived because those are permanent bar. For example, frivolous asylum claim, fraudulent marriage, sham marriage, or falsely claiming U.S. citizenship. Those are the immigration offenses that cannot be waived. Once it's done, unless you appeal, unless they reverse the decision. Otherwise, it's final, it's done. So, but those are the people who will be able to get parole in place. Parole in place meaning that they're just waiving unlawful entry. They are going to tell us exactly what form to use, but I'm assuming because we already know how parole works, it's probably going to be the form I-131 and initially a work permit by filing the form I-765. Once you have been paroled, then you can adjust status, okay? Once you've been paroled, meaning once they've waived that, a person can adjust status by either filing I-130, I-145 together with USCIS, or I-130 by itself if the person still has to deal with removal proceedings, all right? So the rules that goes with adjustment of status did not change. The only thing they're waiving is unlawful entry. So that's why they are paroling people, giving them permission to adjust status inside of the United States. That's a great news. And we talked about documents. If you can watch my previous video, you will understand. Basically, I did 2 lives and I have another small video on what document you need in order to prove 10 years residency. Okay, just go back and watch my previous videos. Number 2, this is bad news. The bad news is that Chavez v. Garland has been overturned by the U.S. Supreme Court, meaning what? Remember, we had a problem with it. Defective notice to appear. People, Chavez actually won, right, in circuit court, and basically allowing people who had a defective notice to appear, meaning the notice to appear in question lacks the date, the time, and the place of hearing. It was deemed defective, and the subsequent notice cannot waive that first one. So basically, people were allowed to reopen their case, terminate removal proceeding, or adjust status, or apply for cancellation of removal. because the initial notice was defective. But now U.S. Supreme Court ruled that it's not. If DHS give you a second notice with the time, the place, and the date of the hearing, then that first one is waived, meaning what? The second one is considered a good one, and you do not have the right to reopen your case and claim that the notice was defective. So basically, Chavez v. Garland has been overturned. Bad news for certain individuals. Not everybody, but certain individuals who had that as a defense, and cases were pending with BIA. At this point, DHS is just going to dismiss those cases. What else? What else we have? We have another bad news. The U.S. Supreme Court decided on Friday, yesterday, that U.S. citizens do not have a constitutional right to question the denial of visa of their spouses. There was a lady who actually went all the way to the Supreme Court to ask the Supreme Court to reverse or to review a decision of the circuit court because her husband was denied visa just because he had tattoos, and those tattoos identify him as a gang member, right? That's what the consulate decided. They saw those tattoos, they said this person is a gangster or part of a gang. He's inadmissible based on that. So they denied the visa, and the lady, the spouse, went all the way to the Supreme Court to get the decision to be overturned. But unfortunately, the Supreme Court decided that they cannot second guess decision of circuit court, or they cannot guess decision of consulate when it comes to visa denial, meaning what? You do not have a fundamental constitutional right to seek an overturn or basically question the decision of the consulate when it comes to visa denial. And that is really bad for certain cases, right? But in terms of if you have to get a waiver, you can apply for a waiver if that denial requests a waiver. But if it's just like it's a denial based on inadmissibility that cannot be waived, unfortunately, that's the final decision. That's the bad news. Again, if you need a consultation, it's always best to schedule it prior to filing. But if you already filed and you are getting requests for evidence letters or notice of intent to deny letters, it's better to schedule again prior to responding to those letters, okay? But if you, unfortunately for you, your case get denied, you have to reopen it, or you want to decide whether to reopen or whether to refile, please schedule it prior to taking that decision. Consultation link is in the description box below. Until next time, bye-bye.